Well, good morning, good afternoon, good evening, and welcome to the first panel of BVI Arbitration Week, supported by the BVI Arbitration Group. I first of all wanted to therefore just to quickly mention the BVI Arbitration Group, which is a group of professionals, not only lawyers, who are interested in arbitration and promoting BVI arbitration in conjunction with the BVI IAC. Our membership is made up of people based in the British Virgin Islands and all over the world, reflecting the attendance at this panel session on BVI arbitration, the Caribbean alternative. I first of all wanted to say after that how very grateful we all are to our distinguished panelists. Hana, Doumal and I are going to briefly introduce them. So I'm going to start by introducing my co-moderator, Hana Doumal, who's the registrar of the BVI International Arbitration Centre and leads the secretariat. Hana's served in the arbitration sector at leading international law firms and arbitral institutions in Hong Kong, Washington, DC, and Paris. And she has experience in commercial arbitration and investor-state arbitration. So thank you, Hana.
Thank you very much, Nick. Good morning, everyone. Good afternoon, good evening. I am very happy to be here with you today, and I will now introduce my co-moderator and the other panelists. So Nicholas Burkill is a partner at Ogier, and he's the head of dispute resolution, responsible for members of Ogier's dispute resolution team based in the BVI. Prior to joining Ogier in 2016, he was head of an international law firm's London trial department and co-chair of that firm's anti-corruption practice group. Nick has vast experience representing clients in international disputes before the courts and in arbitrations, and he has significant expertise in civil fraud, breach of fiduciary duty, and asset tracing cases, among many other areas. He is described as an exceptionally good litigator. He is one of the most experienced lawyers in the BVI and has seen everything. Nick is also the chair of the BVI Arbitration Group. Now turning to Dancia, Penn, OBE-QC. She's an arbitrator and a mediator with 33 Bedford Road chambers in London, arbitration based in Canada, and she's also co-founder of Caribbean Arbitrator, which is based in the BVI. She is a former Attorney General of the BVI, and Dancia has the unique distinction, excuse me, of serving at the highest levels of all three branches of government, executive, legislative, and judicial, having also served as BVI Deputy Governor, Deputy Premier, and Minister of Health, and a judge also of the Eastern Caribbean Court of Appeal. Dancia became Queen's Counsel in 1996 and now is the senior QC in the BVI. She has appeared in the courts at all levels, including Her Majesty's Privy Council. Her extensive legal experience in the Caribbean and beyond encompasses contentious and non-contentious corporate, commercial, and regulatory matters, including in financial services, insolvency, and shareholder disputes, and also a wide range of other areas of private law. Dancia regularly advises and assists clients in the BVI, in the Caribbean more generally, in the US, in the UK, Europe, Latin America, and Asia on matters involving BVI law. Now I'll introduce Anneliese QC, who acts as counsel and arbitrator with Fountain Court Chambers. She is described as a leading lawyer of her generation and an absolute rock star at the top of her game. She's ranked both as a leading skill in 6 practice areas in the legal directories and as an arbitrator. In 2020, she won International Arbitration Silk of the Year and was previously named Construction and Industry Skill of the Year 3 times. Anneliese is often called upon to assist major corporate clients and high net worth individuals with cases concerning joint ventures, private finance initiatives, contract termination, contractual interpretation, and other business issues. She occupies an almost unique position, operating at the highest level in both the commercial and construction spheres, not only in the UK, but also in Asia, the Middle East, the US, Europe, and the Caribbean. And finally, Toby Landau QC, who is a barrister, advocate, and arbitrator, and a member of the bar of England and Wales, Singapore, New York, the BVI, and Northern Ireland. He's also registered in the DIFC. Toby Landau QC is a special advisor to the board of directors of the BVI IAC. He practices in London as a sole practitioner and in Singapore from Duxton Hill Chambers. As counsel, he has had a broad commercial and international practice in London and in Singapore. He has argued hundreds of major international commercial investor state and interstate arbitrations, as well as groundbreaking cases in the highest court of England, Singapore, Hong Kong, Pakistan, and the Caribbean. He is the first QC to have been permanently called to the Singapore bar, and since April 2012, he has been a member of the panel of advisors to the Attorney General of Singapore. As arbitrator, he has extensive experience as chairman, co-arbitrator, and sole arbitrator in commercial and investor state arbitrations under most of the world's leading ad hoc and institutional rules. Now, I will just give a brief statistics on BVI parties in arbitration in general. So we see a lot of BVI parties in LTIA cases. BVI parties represent close to 5% of LTIA arbitrations, and those are the statistics for 2020. BVI is the third nationality in Hong Kong arbitration cases before the Hong Kong International Arbitration Center, after Hong Kong and mainland China. And as for us at the BVI IAC, we see a lot of BVI parties, but we have not released statistics yet. And I can just tell you from the experience that I have here that I've seen cases when where there'll be two BVI parties, so we see that quite often. Sometimes there'll be one BVI party against a foreign party, and sometimes there's no BVI party at all, but the seat will be BVI. So there was just to give a brief introduction on the statistics of BVI parties in international arbitration. And now I will start with my first question to Dancia. Dancia, could you please tell us a bit about the BVI and some more about the 2013 BVI Arbitration Act, and maybe explain how the BVI courts support arbitrations which are stated in the BVI?
Warmest greetings to everyone, and Hana, thank you very much for that question. Let me begin by saying how delighted I am to be a member of this first panel for BVI Arbitration Week 2021, and I'm truly honored to share this panel with distinguished colleagues such as our co-moderators and Anneliese of Queen's Counsel, as well as Toby Landau, Queen's Counsel. BVI has an important and interesting story to tell. We are a small archipelago of islands in the Caribbean. We are within half an hour of San Juan, Puerto Rico, just about 3 hours from Miami, and a little more from New York. So very centrally located geographically. We are constitutionally an overseas territory of the United Kingdom. That means that we have a constitution which is an order in council of the United Kingdom Parliament. And under that constitution, among other things, there is a House of Assembly, which is an elected group of 13 persons, and the Attorney General. And there's a governor who represents Her Majesty the Queen, who is appointed by Her Majesty. It's a small group of islands, as I have said. We have an extremely well-established financial services sector. We are a common law jurisdiction. So our law is primarily the common law, statutes, and of course, there's a huge body of precedent. We have a court with a right of appeal all the way to Her Majesty's Privy Council in London. And as you know, that is comprised of judges of the Supreme Court of the United Kingdom. Our court structure is a High Court of Justice which has 3 divisions, a commercial division, a civil division, and a criminal division. Then there is a Court of Appeal, which sits in panels of 3, and serves we are part of the Eastern Caribbean Supreme Court, and that court serves 9 member jurisdictions throughout the Eastern Caribbean. BVI has, as I've said, a well-established financial services sector. We are very integrated in the global economy, and BVI companies are incorporated and used for a variety of purposes. Very often, BVI companies are holding companies. They enter into joint ventures and various commercial dealings and transactions globally. Many of them are used in succession and succession planning, and there are several other purposes, legal purposes, to which BVI companies are put. As I've said, it's English common law. We are a democratic society. The rule of law is alive and well and strictly adhered to, and the separation of powers is, of course, part of our constitutional structure. We have a strong legal framework, above a very high standard, and counsel from all over the world practice regularly in these courts. We have a very arbitration-friendly judiciary, very arbitration-friendly judiciary. It has always been the policy of our courts, and that is shown in the many and various kinds of decisions which the courts make, that the arbitration is important. Arbitration ought to be independent. The courts do and will give aid and assistance in arbitration matters, but the courts will not interfere in arbitration matters. And of course, the courts can only be as good as the bar. And as I have said, we have a very sophisticated, experienced, and really international bar that practices in our courts. We can offer, and BVI offers, speedy resolution of disputes, legal certainty, which of course is very important, a wide choice of arbitral expertise. We are geographically convenient jurisdiction and very cost effective. And of course, it's a very beautiful place. It's a very beautiful place to visit and a very beautiful place in which to live. And I know I haven't answered all you asked, but I thought I would begin in that way.
Perfect. Thank you so much, Dancia.
Yes, thank you. Thank you very much indeed. And I should say for the audience that our intention is that whilst we've got a couple of introductions to the BVI from Dancia and Hana, what we really want to achieve is to have a conversation both between the panelists and obviously if there are questions from people attending, then we'd be absolutely delighted to answer those either as we go along or at the end, just seeing what looks best from the particular question. And with that a little introductory word, I'll just ask Hana some questions now, because Hana joined the BVI IAC in January 2021, January this year. And so I thought it'd be helpful if you could tell us, Hana, about the creation of the BVI IAC and what you've done and what you've been focusing on since your arrival at the beginning of the year and your main priorities coming up.
Thank you very much, Nick. So the BVI IAC was created by the 2013 Arbitration Act, which entered into force in 2014. They are the current 5 members of the board of directors were appointed by cabinet effective September 2015. And the board is composed of John Beachy, CB, who's the president, Mark Folte, Shona Jallo, QC, Murray Smith, QC, and Felice Swap. I have to mention, I said it briefly in the introduction, but Toby Landau, QC, who's one of the panelists today, is a special advisor to the board. And I also have to mention the Honorable Don Smith, who is a former advisor to the board and the current Attorney General of the BVI. So the CEO of the center was appointed on the 1st of May 2016. It's François Lassalle, and there was a soft opening of the center at that time. The facilities were not created yet, and I wish today was an in-person event so you could see them for yourself. But you'll have just to check the photos and see online for now. So the actual facilities, the building opened on the 1st of January 2017, and this is why when the center was open for business. The team is composed of the CEO, François Lassalle, the center manager, Janet Bren, and our senior administrative assistant, Chantel, who's helping the team coordinate today's event, and myself. The BVI Arbitration Center is an independent not-for-profit institution that was established actually to meet the demands of the international business community for neutral, impartial, efficient, and reliable dispute resolution institution in the Caribbean, Latin America, and beyond. It's a very well-equipped state-of-the-art center with the acknowledged quality of the BVI legal framework and the stable political environment offered by a British overseas territory. And this is what mentioned Dancia earlier, the quality of the bar and of the courts, who are very much pro-arbitration and support arbitration proceedings. So since I arrived, I can say I've really been hitting the ground running. So I've been managing the cases that we have, worked on the creation and the implementation of various initiatives, such as Arbitration Life, that I co-host with Janet Bren. We were very happy to sign a few cooperation agreements with other institutions, such as the HKIC, Arbitral Women, and stay tuned because we're going to sign another one this week with SIARB. We are also focused on writing a few different publications and on BVI arbitration to let people know about the center and how BVI is for arbitration. And we've been engaging with the BVI arbitration community, including the BVI arbitration group, which Nick chairs. I've been working a lot recently on the rules amendments. So we will have new rules in November, so this month. And obviously working on this wonderful BVI arbitration, which is just starting. And yeah, I'm very happy to be a part of it. And the focus for the next few months, I would say, is to promote the rules, let the users know what are the new developments, new modifications, amendments, and procedures that we actually worked on and that are in the rules right now to have more efficient arbitrations in the future.
Great, thanks so much.
Nick and Hannah, before we move on, and sorry to preempt you, but I think it would be very appropriate if we shared with the audience some of the actual features of the BVI Arbitration Act. Is it a good time to do that?
Yeah, that would be great if you could do that now, and then we'll open up the conversation after that, because I think we need that as part of the introduction.
I think so. Yeah. I think it sets the stage very appropriately. It's important that we say that on the 25th of May, 2014, BVI acceded to the New York Convention. So there was the act passed in 2013, brought into force in 2014, and then the accession to the New York Convention in 2014. That was extremely good laying of the foundation. The act is very user-friendly, and it creates, it's the legal basis on which the BVI Arbitration Center was created. And there's some very important and salient features of the act which I would like to share. A very important one is confidentiality, and I know that Anneliese will be dealing with that in more detail later, but I think it's important that we say that there are specific provisions in the Act that deal with confidentiality. The provisions, in fact, prohibit the disclosure, communication, and public hearing of matters involving arbitration. If there is an arbitration matter which is before the courts, and remember that our courts are very arbitration friendly, the files are immediately sealed, all proceedings are held in camera, and only the parties to the arbitration can actually have access to the files to inspect them. Importantly as well, the Act provides for the court to give interim remedies, and I believe that that is one of the very attractive features of the BVI Arbitration Act. It provides for the giving of interim remedies, but of course, the non-interference of the court in respect of arbitration proceedings, and they could be proceedings anywhere in the world. Then there are the provisions as well for the enforcement of awards. Tribunal awards are easily enforceable in BVI, and it was happening prior to COVID, but certainly since COVID, our courts operate virtually, and our courts are very flexible, and there's abundant evidence of this. Our courts are very flexible in the way that they deal with the different time zones. I have known of trials, I believe you may have been involved in one of them, Nick, trials that took place at the height of the pandemic involving different time zones, and the courts, our courts were flexibly enough to accommodate the geographic considerations and the time constraints and so on. Importantly as well, our Act provides that arbitrations can be held anywhere. They need not be held physically in BVI. And that's again a very important feature. They need not be held in BVI. The Act also gives full credence to that fundamental principle of arbitration, which is party autonomy. Throughout the Act, there are provisions that enforce party autonomy, and those provisions in the Act are actually enforced by the rules and in a practical way by the panel of arbitrators, which the board has appointed, and we'll say more about that later. But the panel, I can say now, is very diverse in terms of languages, geographical locations, cultures, gender, legal systems, and so on. Work permits. The persons involved in arbitrations, whether as arbitrators, counsel, experts, support staff, are exempt under the Arbitration Act from the work permit requirements of the BVI, and that's another very important feature. There are several others, but conscious of time, I'll stop there.
I think you mentioned this at the outset, but one of the important points to emphasize is that the Act is based on the UNCITRAL model law.
Absolutely.
And so people will be familiar with the basic provisions because of that. And it provides real assurance.
And also the manner of the drafting of the Act. And I mentioned user-friendly, and as one who has had a lot to do with the making of legislation as a former Attorney General and as a former Minister of Government, parliamentarian, the whole process of lawmaking and the way that statutes are worded is an extremely important thing. And one of the important and attractive features of the Arbitration Act, I think, is the style in which it has been drafted. There's good clarity as to exactly which provisions of UNCITRAL apply and in what circumstances and so on. So it's very helpful to the average reader.
Have been changed. And
very much so.
Yes. Yeah, no, thank you for that. So opening up a bit more now amongst the panel, I'm going to start with a question to Anneliese, which is a sort of slightly self-serving BVI arbitration question. But if I can lob this to you, Anneliese, and ask you to say what you think the advantages are that BVI arbitration offers, and the second element of that question, how the BVI can attract arbitrations.
Thanks very much, Nick, and thanks for inviting me to speak today. It's been fascinating, actually, to learn more about arbitration in the BVI. And one of the things that I think is important, that the selling points are made more widely known. So I had to do some of my own sort of digging around to understand it, and it's been extremely illuminating. So starting from the fact that the BVI is a reliable, stable UK overseas territory, That really has to be a given. But I think then there's lots of things that build on that that are crucially important. Probably one of the big things to me is this issue of confidentiality. So obviously most arbitrations are confidential anyway, but in the BVI, obviously you've got confidential court proceedings. So you start from the fact that arbitration related court proceedings are held in camera, in closed proceedings, and as I understand it, the court file is automatically sealed and cannot be inspected except by the parties. And that's probably an important distinction between other jurisdictions. So if you have parties who are concerned, contracting or parties in dispute who are concerned about confidentiality, I think that is a huge plus for arbitration in the BVI. Obviously, some of the other things have been touched upon. The BVI has an experienced commercial bar that's very well versed in international commercial disputes. You also have a route, well, you have the respected and well-known commercial court in the BVI, and then a route of appeal to the Privy Council in London. It makes me have a wry smile. Toby might not think that the UK Supreme Court is particularly arbitration friendly after some of his recent experiences arguing in front of them. But if something went wrong, then you still have that right up to the Privy Council. As I say, I think that the confidentiality is a really, really big point. I've also been very interested to learn about, and Dancia has touched on it a bit, I think she may come back to it, just about the arbitrators, the diversity, the fact that there's a range of common law and civil law arbitrators who can sit in BVI arbitrations. I think the other thing is having the freedom, parties have the freedom to appoint arbitrators of their choice. So you do not have to appoint an arbitrator on IAC's panel, which I think again might be seen as quite an advantage over some other jurisdictions. And then I think Toby's going to talk about facilities, but I understand you have state-of-the-art facilities, both virtual and in person. But as I say, I think Dancia and Toby know a bit more about those sort of practical issues, but I think the BVI has an awful lot going for it. It's also a neutral, might be seen as a very neutral venue for parties to come and arbitrate in. So I'm sure it's going to have a great future.
Yeah, thanks very much indeed. And I suppose so far as the facilities are concerned, the fact that we're successfully conducting a hybrid panel session now with Dancia, Hana and I in the centre and Anneliese and Toby in two completely separate parts of the world, plus the attendees, does give a bit of a clue as to how we can conduct arbitrations as well. But Toby, I think it's probably a sensible time to bring you into this for the first time. And perhaps you could pursue a couple of the points that Anneliese was talking about, and then perhaps Dancia can then come in with the diversity of the panel.
Sure.
Happy to do so, and very happy to be part of this panel. I endorse everything that Anneliese has said. I think when one's deciding whether a seat or a venue for arbitration is going to be successful, there's a checklist that one regularly uses, which are the factors that one would look to when selecting an arbitral seat. I think everybody, a lot of these have been mentioned already. I would itemize 6 points. And the question then is how many of these one can tick for the BVI. The first key one is something that Anneliese has mentioned, which is neutrality. Neutrality is something which is a matter of perception, actually. It can have a geographic angle, it can have a political angle. When one's looking for an international place for arbitration, somewhere that is perceived as neutral is absolutely vital, which is why places like Switzerland and Stockholm, and to an extent London, Paris have done well. And I think BVI does extremely well on that front. The second factor is obviously the trusted, stable, and familiar legal framework. And that's already been described, and that certainly is a box that gets ticked. There is then, of course, the extension of that, which is the courts and the judges, and the extent to which the legal framework is actually implemented in a way that is recognizable and is predictable. BVI has got a long tradition of very high-level judges and trusted courts. A lot of us at the English bar have practiced in the BVI bar for many years, and it's familiar territory. It's a rigorous, disciplined environment, which I think would instill confidence in anybody. It's got a good track record. On top of that are of course, the next factor, the fourth one, which is the lawyers, the local lawyers. It's no good having a state-of-the-art act and great courts in a great location if you have to instruct a local bar which actually doesn't know what it's doing. And there are many places around the world that would fit into that description, which I won't name. But the BVI doesn't. BVI has got a well-recognized legal profession servicing the courts, and it's one which I think perhaps unusually it draws from many other jurisdictions because of the number of foreigners who have been admitted to the BVI bar. The fifth one would be a good institution. That takes us to the IAC, and I'll say a bit more about that in a minute. And then logistics. And logistics, I think, is one of the big ones and one of the big problems for the BVI. There has been a perception that the BVI does not have ready access in the same way as many other places. And that I think, I mean, it's certainly true that the flights coming to the BVI are not the same as flights elsewhere. One has to get onto a smaller plane and it's less direct, although all these things I think are improving. But actually, when you do get to the BVI, the institutional infrastructure is fantastic. And I have to say that firsthand. And what impressed me most was when I first had a tour of the center in the BVI, which was not long after Hurricane Irma had struck. And it was one of the buildings, the few buildings that was actually intact. And in fact, people may not know, but for some period of time, the BVI court was actually relocated into the arbitration center because that was the one building that was standing, and it was and it had all its facilities up and running. So actually, I think it is actually a brilliant center. It's got amazing rooms. It's got amazing facilities. The only difficulty is the torture of being in the BVI center in a hearing and looking out the window at the beauty and the water sports and the people who are not in an arbitration having a much nicer life. But that comes with it, and one has to just deal with it. But then coming back to the issue of access, I think what is interesting now is that we have, in a sense, moved on post-COVID from the need to be physically present, as this webinar shows. Much of the world of international arbitration is now online. Most people will say that much of it in the future will remain online, even when COVID has subsided. There will always be a need for in-person hearings, but that need is much reduced. And actually, I think it feeds directly into the access issues for the BVI. That the BVI is so now technologically advanced in its center that actually any access issues really shouldn't be a drawback anymore. You can have a BVI and an IAC center arbitration without necessarily traveling wherever you are. And if you need to travel, then it's worthwhile, in my view, given the facilities that are there. So again, I personally am very optimistic about the BVI, but I think it is a question of spreading the message, and that's true for any new center. It takes a long time for clauses to get into contracts and then disputes to arise, and then for them to be heard and for a reputation to be established.
Yes, that's absolutely right, and thank you for that. And obviously, one of the jobs of the BVI arbitration group is to promote BVI arbitration clauses in contracts and encourage that. And Dancia, again, we've touched on this point of the panel of arbitrators and the choice of arbitrators that BVI parties have. But could we explore that a bit more with you, your thoughts on the diversity of the panel?
Certainly, Nick. Let me begin by saying, though, how much I agree with everything that Toby has said. And I'm particularly pleased that he gave the emphasis that he did to the point of access. He couched it under the heading of logistics. But that had been and in my view, an objective criticism and an objective issue for arbitration in BVI. But COVID has brought some good things, and I believe among the good things that it has brought is precisely what Toby referred to, the fact that we've all had to learn to operate more and more in a virtual world, and BVI has proven that it is able to operate virtually in an efficient way.
And in fact, actually, probably the BVI, I mean, there's not been many benefits from COVID, but it is a benefit for the BVI, the fact that the world has recognized that you can have remote hearings.
Indeed it is. Indeed it is. And I think tied into that actually is the panel, because there was great foresight, in my view, on the part of those who established the first panel in comprising it in the manner that it is comprised. Firstly, there's a good combination of the legal systems, the members of which are on the panel. So there are several practitioners from the common law world. There are several practitioners from the civil law jurisdictions. In terms of languages, I believe, Hana, it's 20 different languages, more than 20 different languages are represented on the panels. So language need not be a barrier to the choice of an arbitrator. And Anneliese made the important point that parties are not constrained to choose an arbitrator from the established panel. Parties are free to choose, in the spirit of full party autonomy, parties can choose an arbitrator that they wish to choose. So there is that, the languages, there's the cultural diversity. The arbitrators on the panel are from all over the world. I would expect different religions, different cultural systems, very sensitive to the realities of the world, really. In terms of gender, there is, and I didn't check the statistics, but I know that there's a fair balance of men and women. And let me say that, and I've gotten in trouble, I've gotten in trouble in some of my past lives on this point, but generally speaking, women in the Caribbean stand their own and are in good places in terms of their professional lives. My own law school class, for example, many years ago was predominantly women, and that has continued. And I think in the arbitration world, the same thing is happening in the Caribbean. But certainly on the panel for the BVI IAC, there's a fair representation of women. So geographically as well, it's a very widespread. There are people from Europe, from Latin America. I'm not sure about the African component.
You've been on and off. We're working on that.
Yes, and there are a fair number from the Caribbean as well. So I do think that it's a great strength. It is very much in keeping with the trends, the global trends in arbitration. And as I said, I believe that putting every single thing together, we have a good panel that can serve and give parties the choices which they may wish to make.
Thank you. And it's actually pretty impressive, isn't it? The panel has representatives from, I think, some more than 40
more than 40
countries. Yeah. And just to add to your point about the importance of women in law in the Caribbean, of course, the obvious point to make is that the current Chief Justice of the Eastern Caribbean Court of Appeal is a woman.
Indeed, indeed.
Yeah.
And our bar has a very high percentage of women. And that's not only in BVI, that's really a Caribbean-wide reality. And I think it's a good thing.
Yes.
And I hope the men agree. I'm sure you do, Nick.
Of course. Absolutely. And actually, just throwing this out to the panel more generally, I don't know who wants to answer this question, but how important is diversity in arbitration for parties when they choose an arbitral institution?
Yeah, I mean, I think it's incredibly important. And I think it's, you know, the sort of pale, male and stale view of English arbitrators is something that has been a complaint. So it's a justified complaint. I was talking the other day about the Bar Council's just published some material about not women, but actually Black women being still very underrepresented and not paid the same as their peers, etc. So it is a big issue, and it's an important issue for parties. And I've certainly sat as an arbitrator in Singapore recently where parties wanted a more diverse pool. So I think it's, you know, it's incredibly important, and it shouldn't be underrated. It's also extremely important, all the research about how decisions are made. So I think it's not just about what the parties want, but when you look at how decisions are made by tribunals, if you have a more balanced tribunal, you tend to end up with a more balanced decision. And there's quite a lot of actual empirical evidence about that now. So I think it is incredibly important, and it is something that I see the BVI having a real inbuilt advantage in relation to.
Yeah, thank you.
I would I would completely endorse that. But I think I mean, when one thinks about diversity, it's extremely important, but obviously not just male female. I mean, it's geographic diversity, it's age diversity, it's all sorts of other cultural differences, background differences, etc. And I think we'd all agree that it's extremely important. We'd also all agree that it's taking us a long time to realize it in arbitration. And if you question why that is, I think one of the key factors is that it's not going to come naturally from parties, because when parties make their own appointments of arbitrators, there are many other factors that are coming in the way of just diversity. Ideally, you may want to appoint a historically underrepresented group, but actually what's driving you normally is to win the case. And the strategic forensic issues often will trump diversity issues. If you think the best person who is going to vote for your side is actually a white male, then that may actually win the day, rather than saying, yes, but we want to have diversity. Also bearing in mind what the other party will do. And therefore, the most important driver in the end will be the institutions, because it's the institutions, when they make their appointments, that they have really the ability to create diversity. And we've seen that already in the last few years. There have been great strides made by the world's arbitral institutions in the appointments that they make when they're constituting a tribunal. And I think that's also a sort of an important role where the BVI IAC can really pull its weight, actually.
Yeah, thanks very much. And Hana, I see that there's one question come up on the screen about how people can apply to be on the panel of arbitrators. I don't know whether you're the right person to answer that.
Sure, yes. Well, thank you for your interest. It's very nice to hear. All the information is on the website. And if you are not able to find it, please just email the info@bviiac.org and we'll communicate all the information. So for this year, we are still receiving applications. We will examine them in December, January, to be able to give answers at the beginning of February. But thank you again for your interest. And we're working hard on that. We really want to have nice representations for parties to choose from or not, because it's up to them. Mm-hmm. And we want to have more arbitrators from Africa, more from Asia, more from everywhere, more from the Caribbean too, actually. But this is something we focus on.
Yeah, thank you. And I think we wanted to put in an update from you, Hana, on the BVI IAC rules. And if you could just do that, maybe the sort of headlines of it, that would be great. Absolutely. I'll just give you a sneak peek, because we have our session about the rules amendment on Wednesday morning, so stay tuned for that, with the members of the Rules Amendment Committee, which are Chan Bao, Charlene Tong, Christine Artero, Victor Bonin-Renes, and Thomas Granier. So they will be with me and we'll be introducing the new rules. What can I say? I'll just give you some of the new provisions. So there will be a new provision on emergency arbitration, new provision on expedited procedure, one on the tribunal secretary's role, duties, functions, some new provisions as well about multi-parties, multi-contract, joint consolidation, and
the very important amendment in the rule, which is the introduction of an arbitration committee to review and ensure the application of the rules for procedural matters mostly, and also to assist the CEO in appointing arbitrators.
Thank you.
So now it's my turn to ask you a question, Nick.
I prefer asking the questions.
And Dancia touched upon it earlier when you were talking, about the enforcement of the rules in the BVI,
Yes.
and how it was quite an easy process here. So actually, it'll be good to hear more about it. How actually arbitration friendly is the BVI as a jurisdiction in terms of enforcement? Maybe could you tell us a bit about the conditions of enforcement of an international arbitration award seated in the BVI or abroad? Is there a difference? And also an interesting question that I'm sure people want to know, what is the length of a typical enforcement proceeding?
Sure. And again, I'm conscious of the time, so I'm going to again just give headline responses to that, because I think there's a great question that I wanted to ask at the end as well, before we ran out of time. BVI acceded to the New York Convention in May 2014, so we're a New York Convention country. And so obviously there's the distinction between convention and non-convention awards when it comes to enforcement in the BVI. But the simple answer to your question about the length of time it can take, obviously if there's a challenge, then that extends the process. But where there's no challenge, then our experience is that you can get an award enforceable in the BVI within a couple of weeks. And that compares really favorably with the enforcement of foreign judgments, where, as in a lot of other parts of the world, absent some particular treaty, the way to enforce a foreign judgment is to sue on it in BVI proceedings, and so that's although whilst you can go for summary judgment, that's a question of months rather than weeks. And the other point that the final point I wanted to quickly make was the importance of enforcement in the BVI, and the reason for that is that BVI companies are often holding companies. And therefore that produces a load of important enforcement possibilities as you go down the corporate chain and get to assets around the world because they're held by a BVI company. And that's a really important point for people to bear in mind when they're looking where to enforce their award. And so in the last few minutes, I wanted to ask a composite question for all of Dancia, Anneliese, and Toby, to ask you about the attraction of BVI arbitration to either persons in your particular regions or disputes from your particular regions. And I don't know who wants to kick off answering that. Because we've got 3 people from different parts of the world, and I thought that was a great way to reach.
I'm happy for Anneliese or Toby to start.
Well, obviously, for people from England or Europe, it's the water skiing that they can get some sunshine and go out in the evening. But no, on a more serious note, I think obviously it's a potential challenge. Why should you get people from the UK and Europe to go to the BVI? But I do think this confidentiality issue is incredibly important. It's also, the world is so small now. I sit here in England, particularly post-COVID, and deal with people all around the world, clients all around the world, a lot of whom have money or businesses that are linked to the BVI. And I think the neutrality of the venue will be important. I think the diversity is important because people want good quality arbitrators, as Toby has said, and it opens up a new pool of new people to deal with cases. The other thing that I think might be worth mentioning is actually, obviously, COVID is hopefully going down, but is still here. And one of the challenges that has been faced recently is a situation where parties want a hearing in person, actually, but are trying to find a venue that lets people in. And so it might be said that the BVI is actually more COVID secure. You can test people, you can come in, you're not going to have the issue. I've got one where parties want to move from London to Dubai, which is pretty unusual. But it's partly because the government in Dubai will recognise different vaccines, but also it's felt the risk is less of people travelling around Dubai than getting on the tube in London. So I think that's an interesting, actually, may become traditionally it's been seen as more difficult to get to the BVI, but it might actually be seen as more secure. And we've also all had to deal with situations where somebody gets sick with COVID during a hearing and having to negotiate all of that. So it may be felt to actually be secure physically as well as secure from a confidentiality point of view.
Yeah, that's an interesting point.
I can follow on from an Asian perspective. I think there's a well-established access between Asia and Caribbean. A lot of practice bridges PRC, Hong Kong, Singapore, and the Caribbean because of the amount of offshore company structures and trust structures that are set up from Asia or involving Asian parties. So a lot of us who practice in Asia also have a parallel connected practice in the Caribbean in any event. I have had many cases where I have argued part of the case in Singapore, and then I have flown to the BVI and I've argued another part of it in the courts in the BVI, which, by the way, is the most incredible anthropological, going from Singapore and people rushing along the streets and answering their emails 2 seconds after they've been sent, and then landing in the Caribbean where things are a little bit slower and life is taken at a different pace. So I recommend that shift to anybody. I think the having a viable arbitration system in the BVI is a natural alternative to the viable court system in the BVI for people with Asian interests or with structures that necessarily entail the BVI. So I think it's an easy fit actually for Asia in the current system that we have, which is just pointed towards the BVI court, and I'm hoping in the future it will be pointed towards BVI arbitration as a natural alternative.
Thank you.
Yes, Nick, I agree with what both Toby and Anneliese have said. I would add that in terms of the Caribbean, Latin America, North America, geographically, our proximity to those countries and our own location is an asset. Language and the facilities which this arbitration center offers for interpretations and translations and so on is an important factor. And the point that Anneliese made about COVID, I hadn't thought about it, but she's absolutely right. And it's very interesting. At the present time, I believe, I see you're watching the clock, Nick, so I'll be very quick. But at the present time, I do not believe that there are any restrictions. Once a person is vaccinated, double vaccinated, I think you can enter BVI without having to quarantine or any such thing. And just the air quality and the physical space and all that would probably make it at this point in time a very interesting possibility as well. I just wanted to mention very briefly the rest of the Caribbean, because we are one geographic region. And it's clearly evident in the last few years that there's been a growing interest in arbitration. There's a growing body of individuals being trained as arbitrators, not all of them lawyers. Even in our group, Nick,
yes,
we have quantity surveyors and engineers. So there's a growing body of expertise and a growing interest throughout the Caribbean. And I focus primarily on the English-speaking Caribbean. There's a jurisdiction like Guyana, for example, which has a huge energy sector and where oil has fairly recently been discovered. We don't have time to go into that. But there are jurisdictions like Barbados, for example, which has set up its own arbitration center. There's a Jamaican International Arbitration Center, and the competition is friendly. but I thought it was right, while we focus on BVI arbitration, to also mention that there are interesting possibilities in the Caribbean, and even for those jurisdictions, BVI and our center offer great opportunities.
Yeah, no, thank you for that. And I think that another point to make in relation to the Americas is it's a relatively close time zone, or the time zones there are relatively close to us.
And everybody from there comes here to sail.
Absolutely. And of course, there are a lot of people in the BVI who go to the Americas, whether for holiday or for business. So we know that it's pretty easy to get to the Americas from here. So there is that geographical attraction as a neutral venue relatively close by for disputes from those areas. I think we've probably reached the stage where we should close. I think we could have carried on for a lot longer. It's been a fascinating discussion, and thank you very much indeed to Hana and to the panelists, Anneliese, Toby, and Dancia. Thank you very much indeed.
Thank you all very much. I've enjoyed it tremendously.
Thank you. Thanks so much.
Yes, no, thanks so much.